is working again, and I'll get started. And let me just say this clearly as possible, right? In responding to Wilma's question, had said, look, we should, really recognize that it's going to be very hard for us to come together and do serious constitutional politics in 2025 or thereabouts because we are so fractured, we're so divided, our media environment is contributing to that. We are in the process of fundamental changes to our society, whether they be economic or cultural, that many of us find to be quite threatening. This may not be the opportune time to revise our Constitution. Let me say in response to that very, I think, forceful and important objection or consideration, we also have to ask, is this going to get worse or better? If we don't try it now, will we be facing complete constitutional breakdown in the not too distant future? And if so, as hard as it's going to be to do it now, is it going to be even harder when we can no longer escape doing it? So those are questions that I hope what we will discuss in the next few weeks will help us to begin to think through. But my question for today is an even more extreme question. Should we give up on the Supreme Court? And the question is, in part, should we give up on the Roberts Court being any kind of check on the autocratic, racist policies of the Trump administration, right? And those are two distinct categories, but they do go together, right? The fact that the immigration and customs enforcement are being used against primarily persons of Latino descent, Latin Americans within our own country, or Hispanic Americans is a sign of, on the one hand, growing racism, and on the other hand, growing autocracy. And in a decision that came out in the last week, I find deeply distressing. The Roberts Court seems to have given not only the green light, but a certain kind of constitutional legitimacy to these politics for the time being. So that's one big question, right? The urgent, the immediate question in 2025. But then there's the second, and in a sense, the more profound question. As we begin to think through what would a better constitution for the 21st century look like, should it contain a Supreme Court? Should it contain a highest court given the power of judicial review? That is the power to invalidate both legislation and executive action. Should we continue to trust 9 rulers in robes to do that work? And go right ahead, please. And you're still muted. Can you unmute yourself?
Got it.
Good.
As long as the court, whatever our top level of ruling should be, as long as that organization does not believe in the rule of law, it's not going to work.
Yeah, and so
And the other thing is that they are functioning not as a deliberative body. All of these shadow docs that are coming out with no reasoning or anything else, they're ruling by fiat.
you're previewing exactly what I want to speak with you about today.
Good for me.
Yeah, so on the one hand, Stephen Vladeck, right, the person who coined the phrase shadow docket to refer to the emergency docket, said the other day, they're not acting like a court, right? And that's a pretty damning complaint, right? Not just they're not acting like the Supreme Court of the United States, our highest court, our right most important forum of principle about what the Constitution means. They're acting like a star chamber. They're acting like a right monarch, an institution of supreme authority that has no accountability. And when we say acting like a court, I think we mean deliberative, right? But I think we could also talk just a little bit about judicial virtues. They're supposed to be reasoned. They're supposed to be patient. They're supposed to be non-partisan. They're supposed to be principled. And when the court doesn't issue decisions. And when, right, that's the nature of the shadow docket, right? No full developed decision, just an order, a holding, right? And on the other hand, when they seem to always side with one partisan side to a dispute as opposed to the other, then we begin to suspect no, they're not a court, right? They may have black robes, but they're really just partisan judicial functionaries. And so that would be part of the reason why we need to entertain the question, should we give up on this court, the Roberts Court, ever rising to the challenge of the 21st century? But then I guess the additional question is, does that indict the very institution? And let me be as clear as possible about this. Let me get back into my slides, but I'll start here, right? I think if we were kind of doing a historical analysis of the Supreme Court that divided it into two columns. When was the court on the side of the powerful? When did it rule in ways that damaged democracy? When did it fail to indicate the genuine, principled, moral content of the Constitution on the one hand? And when, on the other hand, did it actually get it right? Did it actually succeed in articulating the value of the Constitution in a way that made it relevant, that extended it, that made it speak to the demands of the moment? It might be that 90% of the time the court is on the wrong side from the vantage of historical retrospect, right? We've got our Dred Scott, our Plessy v. Ferguson. I'm about to speak with you about Korematsu. We've got these decisions that subsequent courts view as stains on the history of the Supreme Court. That's how bad the decision was. And by the way, those kinds of decisions outweigh the right Brown v. Board of Connecticut, the right I'm sorry, I'm running cases together here, trying to think on my feet. Brown v. Board of Education, the Connecticut decision about birth control and women's rights to control their own bodies, right? Those are the decisions that at least people like me look back on and say, yes, the court really did the difficult work of driving the Constitution forward, and with it, American society and American politics. It may be, right, that the bad decisions outweigh the good decisions 9-1, but that the 10% that they got right justified the existence of the court. Because frankly, without the court doing that work, we would have just been 100% wrong. We would have just never progressed as a society, or else the progress would have been much slower, right? And that's an interesting, important, essential question to answer when we answer the deeper question. Should we give up on any Supreme Court altogether? And part of the answer then depends on well, under what circumstances does it actually function in the way that we need it to function for constitutional democracy? Either to protect our Constitution from the infringements of highly animated, highly partisan, transient majorities, or to actually detect the longer term implications of our constitutional commitments to each other. If we don't have some answer to that question, it makes it really hard to figure out what we should want from our court. That's where we're going together. So Anne, thank you for the setup. Let me jump right in and say to you why it is that I'm raising this question today. And it has to do with a decision that the Supreme Court reached on the shadow docket at the beginning of this week in the case Nome v. Perdomo. This is about the roving sweeps that ICE is doing in the Los Angeles metropolitan area. And the fact is that a lower court judge said, look, this is a violation of the Fourth Amendment. We have a right to not be subject to unreasonable search and seizure. And the policy that ICE is pursuing, just going into Home Depots, going into construction sites, going into parks and neighborhoods, and rounding people up without any right prior suspicion that the person in question is in the country without documentation or legal permission means that they are targeting indiscriminately citizens as well as non-citizens on the basis of a racial or social profile, and the Constitution protects us against that, right? And what the Supreme Court did in this decision is to prevent the lower court from issuing an injunction saying to ICE and the Trump administration, you can't do that, right? You need to have more specific criteria, more probable cause before you start hauling people out of Home Depot and questioning them. So the idea that this is the 21st century version of the Korematsu decision. I imagine most of us are familiar already, but Korematsu was the Supreme Court case in which the court said the United States government at the outset of World War II is justified in rounding up Japanese Americans, dispossessing them of their property, of their homes, of their businesses, throwing them into internment camps and holding them there indefinitely because we worry that just because you're of Japanese descent, you may favor Japan over the United States in World War II. You may, in fact, then be part of a third column attack on the United States, or you may share intelligence with the Japanese. Now, this occurs in the immediate aftermath of Pearl Harbor, right? At one of those moments where, right, the President of the United States is mobilizing anti Japanese hatred, racism, in order to drum up the patriotism of the country in entering World War II, something that many Americans have been reluctant to do for a long time. It occurs in the aftermath of a violent surprise attack that had killed thousands of American sailors. Having said that, that's exactly the kind of circumstance in which we rely on the Supreme Court to force us to abide by our deepest principles, even in conditions where we may be wounded, we may be angry, we may be carried away by our passions, and the court ultimately regretted that it did this. Obviously, allowing ICE to detain citizens on the basis of only their skin color, their language, their accent, their social profile is not the same as rounding them up and putting them in detention centers indefinitely. But having said that, I think people like me believed that the regret over Korematsu meant that the Supreme Court would be much more skeptical of broad-based governmental racial profiling as the basis for um, targeting citizens for potentially chilling political persecution. And that is, it appears, not the case in 2025, at least not now, right? It may be that eventually the court will hear this case on the merits docket, not on the shadow docket, and the result will be that it does not allow ICE to use race as a proxy for uh, being undocumented, being here without legal permission, and that it will recognize what I think should be obvious, which is that this is going to deeply affect the sense of equality and belonging of the largest racial minority in the United States. It's going to continue our sad history of racial privilege and hierarchy. It's going to make people who already feel threatened and marginal feel still more threatened and marginal. Let us hope that eventually those arguments prevail. But for the foreseeable future, right, ICE gets to continue to target people. And this really makes me wonder whether this court is up to the task of 2025. Let me say a little bit more about it. Um, so the issue here, right, and I'm going to start with the legal issues and then move into the values and then move a little bit into what evidence the court gave us for why it decided what it decided. The issue is, on the one hand, does race, language, and social profile allow ICE to perform roving sweeps targeting a substantial minority of American citizens for at least short-term detention? Does that meet the constitutional threshold of reasonable suspicion, right? The government can't just force its way into your house and look around and see what you're doing and see if maybe because you live in the wrong neighborhood, you are engaged in crime, right? It needs a warrant. But having said that, if an officer pulls you over on the highway, right, and suspects you of a crime, the standard is lower. He does not need to get a warrant. He just needs probable cause, and that probable cause needs to hold up in court. If you're in a shopping center, maybe the standard is still lower, reasonable suspicion. And so this idea, right, that there's less expectation of privacy in the shopping center than there is in the car, less expectation of privacy in the car than there is in your home, guides how the government protects your privacy. But the question here is, is shopping while brown a reason to expect that you should be detained by the government? And how invasive and burdensome are these searches? And the person in this case, Perdomo, apparently was thrown to the ground, handcuffed, and detained for hours. His ID, his driver's license confiscated and not returned, right? It doesn't sound um, routine. It's not like a traffic stop, right? And so this man is a citizen, right? Eventually, ICE let him go, acknowledged that he was a citizen. But now any brown person has to worry that they could be subject to the kind of treatment that Perdomo was subject to if they shop in the wrong place at the wrong time, if they work in the wrong place, if they have the wrong accent, right? And so the question I think that the law asks us to answer is, does this kind of, right, treatment by an agency of the US government merely inconvenience people in the way in which being pulled over on the freeway inconveniences you? Or does it in fact chill their ability to enter public space with the sense of security and equality that all citizens should have as they enter public space? I'll now pivot from the legal to the value question. And it seems to me the value question should also be at the heart of what the Supreme Court is considering as it considers a case like this. Does this policy show equal respect for all citizens and persons? Right? And should the court protect the full and equal inclusion of all citizens as full and equal citizens of our society, members of our society, members of the community of citizens of the United States? Does the failure to do so not express an implicit racial hierarchy? And here, right, the idea that, well, we're minimizing the quote, invasiveness or burdensomeness of these kinds of roving searches and seizures, the chilling, intimidating, fearful effect of knowing that ICE can detain you simply on the basis of your skin color and accent, that this expresses a failure of empathy, a failure of moral imagination, a failure to understand what it would be like to live in a society where somebody could point at you because of your skin color and say, you, right, come here. And if you don't cooperate very quickly, you're on the ground and in handcuffs. Or if they don't like the way you look, who knows, right? What is to guide their treatment of you? That if you are white, I'll say this very quickly. I was pulled over by the police just a few nights ago. I had a burnt out tail light, brake light, and they, gave me a little. It's a thing where I got the brake light fixed within 24 hours, so I don't get a fine, but it would have been a fine. But it was certainly not a pleasant experience for me, right? Your heart races. I don't know about you, but I do find that being pulled over by a police officer inspires or produces a little bit of fear. But I'm not someone who has to worry about going to Costco or Home Depot and being targeted because of the way I look. Quite to the contrary, I suspect I'm treated with a fair deal of deference and respect by the police when I'm pulled over because of the way I look. But does that mean that I can't imagine what it would be like to be someone who's not afforded that prima facie respect? And I do think, in a sense, the court needed to rise to the challenge of moral imagination to say, you know what, if I were Brown, I'm not sure I would regard this as a mere inconvenience. So I want to now quote just a little bit to you from an earlier John Roberts decision. This is actually the Muslim ban decision, Trump v. Hawaii. I think this is 2017. And he wrote in that case, as they upheld the Muslim ban, that the right, that this was nothing like Korematsu, and so the idea of using a profile of Muslims as a potential national security threat to heighten immigration scrutiny as they're trying to enter the country is not the equivalent of Korematsu. Roberts wrote, Korematsu was gravely wrong the day it was decided, has been overruled in the court of history, and to be clear, has no place in law under the Constitution. Now, I want to turn to Sonia Sotomayor's dissent in the shadow docket ruling, right? And Brett Kavanaugh wrote a concurring opinion, and this is part of what I'm relying on in suggesting that this is a failure of moral imagination on the part of the majority of the Supreme Court, because Kavanaugh says, look, what happened to Perdomo is a minor inconvenience. Sotomayor, who probably has more sympathy for the people who look like her, who come from communities like the community she came from, in terms of then the capacity to understand that being targeted for legal scrutiny just because of the color of your skin or the nature of your accent suggests to many people that they are second class citizens. This is what she says. The Fourth Amendment protects every individual's constitutional right to be, quote, free from arbitrary interference by law officers. She's quoting another Supreme Court decision there. After today, that may no longer be true for those who happen to look a certain way, speak a certain way, and appear to work a certain type of legitimate job that pays very little, because this is unconscionably irreconcilable with our nation's constitutional guarantees. I dissent. And we've noticed this, right? This pattern in recent Supreme Court dissents of not saying I respectfully dissent. And this is yet another right dissent that does not evince respect for the majority's reasoning. And I think you can understand why, right? That the idea that the Supreme Court is going back in time to a period when it was much more permissive of racial profiling, of differential treatment of citizens on the basis of race, um, means that the majority does not deserve the respect. Its opinions certainly do not deserve the respect. What it is allowing this administration to do does not deserve the respect of the citizens and the judges of the United States. So let me conclude today. I know we're already running out of time with a brief review, but also an amplification in light of what we've just said. Right? I have various motivations. I want to refresh my ideas here, right? That lead me to raise the question: should we still have a Supreme Court? Part of it is the radicalism of the court itself, and that is provoking these calls for reform or abolition, and raising the prospects of a crisis of constitutional democracy or democratic constitutionalism. I have on the board Stephen Tellis's book, right, The Rise of the Conservative Legal Movement, and I pointed out to you before, it cost $500 million to get a court composed in this way. This was a sustained partisan political campaign. It's continuing, and by the way, the court majority is acting like people who have been, right, funded by a sustained partisan campaign. The second question is one about whether the fracture within the Supreme Court and the federal judiciary is raising a constitutional crisis, an intra-institutional crisis, a crisis within a single institution. We've looked at Sotomayor's dissent in the Janus case. The majority road, right, runs long, and at every step are black robed rulers overriding citizens' choices. The First Amendment was made for better things. It was meant not to undermine, but to protect democratic governance, right? And so the claim on the part of one of the justices of the Supreme Court that the Supreme Court is becoming a counter democratic institution, I think is one we need to take seriously. The idea that Trump is threatening democracy and that SCOTUS is not only abetting him, but also, in fact, giving him constitutional cover for what he's doing, and so doing undercutting its own legitimacy. I'm going to jump forward to another shadow docket ruling. Remember, right, that Justice Jackson, in just incredibly cutting dissent, accused the Supreme Court of playing Calvin ball, right? Which is to say, right, that it has only one rule. There are no fixed rules. We seem to have two, that one and that this administration always wins. And I want to point to a recent decision, Judge Burroughs in the Massachusetts circuit in one of the NIH cases, right? Harvard's National Institute of Health grants were canceled by the Trump administration. Harvard sued. She's finding for Harvard against Right Health and Human Services, which houses uh, the NIH programs in question. And she says in her decision, right, it may well be that these differences would not distinguish these claims in the eyes of the Supreme Court. And I'm skipping some of the technical details, but the question is which court has jurisdiction? Is it the Federal Court of Claims or a federal district court? Although that remains unclear under existing case law. But this is not Calvin Ball. And there are rules. Under those rules, which are set by existing Supreme Court precedent, this court cannot conclude that core First Amendment claims or pure statutory violations fall within the exclusive jurisdiction of the Court of Federal Claims. And so I want to be as clear as possible. This is a district court judge pushing back on the Supreme Court. She continues in a footnote to say that look, we're mindful of the fact that Gorsuch, in another decision, just excoriated a lower court judge. But right, the idea that the Supreme Court is using the emergency docket, the shadow docket, means that there's lack of clarity, right? Their rulings have not been models of clarity and have left many issues unresolved. And then she points to this particular decision in which there are two 5-member majorities, but 4 of the justices clearly disagree with each other. It's only Amy Coney Barrett switching sides in the case, in right, joining 4 on one issue, 4 on another issue, that allows the case to be resolved. It's a mess, right? And the lower courts are increasingly saying to the Supreme Court, you're a mess, right? We don't know what to do. And how can we respect you and respect you both, right? um, in terms of your role in our democracy and respect you in the narrow legal sense. Respect your decisions if we can't understand them because you did it on the shadow docket without any written guidance that allows us to figure out what we're supposed to do. So I think I need to leave it there for today. But I just want to say this is another week in which the Supreme Court seems to be showing its true colors, and they appear to be wearing red MAGA hats as opposed to doing their jobs. This is another week in which the lower courts are basically saying to the Supreme Court, we don't understand what you want us to do, so this system is not working. That's deeply troubling. Flossie, go ahead. Flossie, as usual, you need to find either the space bar or the microphone button. I saw somebody in the background. Can somebody help you, Flossie? Anybody else want to ask a question while we're waiting for Flossie to be able to unmute herself? Okay, good. Looks like Flossie's getting help. There we go. Go ahead, Flossie.
Just one question. What happened to Jeffrey Epstein? Where does that put our president? He is our president. He is also a pervert. He also has a lot of different criminal charges just with respect to Epstein. I'm not excusing Epstein, nor do I believe that he hanged himself. He had a lot of help. But the president was his best friend. The president courted him, embraced him, and sent his woman to jail, and also welcomed those who probably saw him and put the rope around him. I leave us with that. People are being put into jail, deported, but we have a president who has a criminal record and a very, shall I say, interesting criminal record. And we're letting that happen. Where is, where are the women? God bless Sotomayor. Where are the other ladies?
Well, I guess one question is, does Amy Coney Barrett have any sympathy for the women, as you put it, right? But the three liberal justices, it's worth noting, are all women, right? Two of them
Right.
women of color, right? And so there's I think when I speak of the failure of moral imagination, um, that there is one African American man in the conservative majority, and I'm not sure what to make of him, to be honest with you. I won't speculate, but the idea that the rest of the conservative majority is white and just looks at these issues from a different perspective, that most of them are men, and that leads them to look at this from a perspective that does not have sufficient empathy for the people who might be the victims of this administration. I'm going to come to Epstein just glancingly. I don't know what to say, Flossie. I wasn't there. I'm not privy to the information, and I don't see that there's much value in speculating. But I will say this, and so I'm going to pivot from Epstein and as you note, right, Maxwell seems to be given some preferential treatment. She's transferred to a low security prison, which means reclassifying her as not a sex offender in order to allow her to, right,
Naturally.
get better treatment.
Yes, who's pretty
But having
seen.
said that, what I will point to, and I think it's worthwhile noting, right, is that Donald Trump has been convicted on multiple counts, right, to do with business practices, right, and that his federal housing finance agency chief seems to be going through the mortgage applications of the people that Donald Trump hates most or most wants to have power and leverage over, and using that access to private applications to generate leverage and criminal charges, not because they're doing a systematic review of everybody's mortgage application, even everybody in the Trump administration, right? They're just going after the people Donald Trump wants leverage over from a president who himself has been convicted of things far worse. I think it speaks to the degree of hypocrisy that you're pointing to, Flossie, and that can leave speculation about Epstein to one side for now. David, you've got your hand up. Go ahead, please.
Yeah, I just wanted to say when the court turned more conservative and Trump got his appointees, I expected, given the history of most jurists, whether they're conservative or liberal, that we would have a return to the traditional conservative principle of stare decisis, let the decision stand. So we would have a court that would uh, not be too active in pushing laws in different or precedents in different ways. But instead, what we got is a court that either plays by the variation of whatever Lola wants. Lola gets substitute Donald for Lola. Either that court or else the court that says, you know, times were better in the past when white people ruled the world, and those who weren't white aspired to be white. And so let's return to that. And it seems to me that you can explain a lot what they do by saying that they're hearkening back to the same periods of time that Trump harkens back to. So that's my bitter analysis of where I think we are with respect to this court.
Yeah, thank you, David. And we talked a little bit about this last week. We tried to sympathetically reconstruct what the Roberts Court super conservative majority is thinking, right? When it rules in these ways. And it appears that part of what it is thinking is that much of
We
the,
lost you.
can you hear me?
We can now. We lost a whole sentence or two.
Okay, so I was pointing out that last week I tried to
Yeah.
sympathetically reconstruct what maybe the Roberts Court is thinking, and that part of what it seems to be thinking is that what the Warren Court and the Berger Court and maybe even right subsequent courts did, right, either in upending precedent and right note that right Brown v. Board overturned Plessy v. Ferguson, right? And so we don't always want a court that simply lets decisions stand. If they're awful decisions, they need to be overruled. But having said that, this court, as opposed to, and here's a distinction that I'm going to try to develop as we go forward, following what you might call organic or natural, logical progression of the development of the values of the Constitution, which is what I believe the Warren and Berger courts believe they were doing, instead says no, everything that came before has to go away and we have to go back. It's a radical about face. And so not only does it not respect precedent, it refuses to see either that there was moral learning in
This
what
has gotten ridiculous. We miss every other sentence.
Yeah, we'll have to revisit this, David, because we
Yeah.
can't. We're missing every, as Zan said, every other.
Okay, I'm sorry, Anne. I'm sorry, everyone. I will try to get my new computer set up, but I'll also try to call Verizon and see why my Wi-Fi is so bad. I can see that I've got fewer bars than I should have.
David, maybe we can. We're missing every other sentence from you, so it's hard to follow. So maybe we can revisit it.
Yeah, I'm trying to
Okay.
apologize and
Get that
let you
computer
go.
fixed.
Pardon?
I
Yeah,
think it's probably.
or it's the internet, but yes.
Okay.
Sorry, guys.
See you next week at 1.
At 1 o'clock, and we'll make sure that the word gets out.
Very good. All right,
Thank you.
everybody. Sorry for the interruptions. Good as always being with you. See you next week. Bye, guys.
Thank you, David.
Pleasure as always. Thank you.
Bye.